Members of the jury, I know of no duty of a citizen that is at all comparable in importance with that which falls upon a member of our community who is called upon to sit in judgment upon a fellow human being and to pass upon a case involving the liberty and the future of a person accused of crime. Although this trial has lasted almost a week and considerable testimony has been taken, nevertheless, the fundamental issues of fact to be determined by you are extremely simple. Before instructing you more specifically respecting the law applicable to this case, I shall state to you some general propositions of law applicable to all criminal charges which you gentlemen are to bear in mind throughout the consideration of this case and by which you are to be guided in arriving at your verdict. The defendants are presumed to be innocent until the contrary is proved. The effect of the presumption of innocence is to cast upon the people the duty of coming forward with evidence to prove the guilt of the defendants. The people have the burden of overcoming that presumption. They have the burden of establishing the guilt of the defendants beyond a reasonable doubt. If you have a reasonable doubt as to whether their guilt is satisfactorily shown, you must give them the benefit of it and acquit them. A reasonable doubt is such a doubt as a reasonable and intelligent man, after a full and fair review of all the evidence, can conscientiously say that he entertains, and for the entertaining of which he can give a good reason based upon the evidence or the lack of evidence of the particular case. It is such a doubt that you cannot conscientiously say that you are satisfied to a moral certainty that the defendants are the persons who committed the crime charged in the indictment. You are the sole judges of the credibility of the witnesses, and if you believe that any witness has willfully testified falsely to any material fact, you must disregard the testimony that you believe to be exaggerated, colored, biased, or willfully perverted. You are the exclusive judges of all questions of fact. It is my duty, gentlemen, to state to you all matters of law that are necessary for your guidance in reaching your verdict. It is for you to say what conclusions of fact you will draw from the evidence. It is for you to tell me, gentlemen, what are the legal consequences of the facts that may be found. You are bound to receive as law whatever is declared by the court, and for the purposes of arriving at a verdict, you are to apply the facts as you find them to the law as I stated to you. In the course of my charge, I may refer to the evidence, and if your recollection of the evidence differs from mine, your recollection shall control. You are to decide the facts on the evidence and the evidence alone. The denial by the court of motions made by counsel for dismissal of the indictment does not indicate that the court has found any opinion as to the guilt or the innocence of these defendants. The grand jury found an indictment against the defendants, charging them with crime of assault in the first and second degree. Upon motion of counsel, which was consented to by the district attorney, the first count of the indictment was withdrawn from your consideration, so that now the charge as submitted to you is that of assault in the second degree. An indictment is an accusation in writing charging a person with a crime, and the mere finding of an indictment by the grand jury is no evidence of guilt. It is not even a circumstance to be considered by you, because the burden of establishing the guilt of the defendants rests upon the people throughout the entire case. It is alleged in the indictment that on the 12th day of August 1994, with force and arms, the defendants willfully, feloniously, and wrongfully made an assault upon Wells with a weapon which the defendants held in their right hands, and that they did feloniously, willfully beat and wrongfully inflict grievous bodily harm upon him, and that they struck him, causing bruises, lacerations, and other bodily harm. Gentlemen, it is the contention of the people that this assault was caused by the defendants without any provocation or justification. Whatever the contention the people have advanced, if you must not be taken conclusively by you, but you must weigh the evidence and give it that consideration which you believe it is entitled to determine whether or not that contention is upheld by the evidence. I do not propose to review the facts, because counsel on both sides have discussed that with you intelligently, carefully, and in great detail. The law under which the indictment has been based provides as follows. A person who, under circumstances not amounting to the crime specified, that is, not amounting to assault in the first degree, willfully and wrongfully wounds or inflicts grievous bodily harm upon another, either with or without a weapon,